Welcome to Real Estate Focus. Our topic is Landlord and Tenant Law. With me here today is Bill Sienkiewicz. He is the principal owner of Sink Law in Braintree. Sink Law specializes in real estate, estate planning, and corporate law. Welcome, Bill.
Thank you for having me, Calvin.
Thank you for being here. So we're going to talk about landlord and tenant law. So the first question is, what does the eviction process work and how does it work in Massachusetts?
Well, Calvin, the eviction process is a very timely and could be costly procedure. When it comes to evictions here in Massachusetts, it's all about timing, process, and procedure. You have to fulfill your rights as timing when it comes to your notices that you give to the tenants. Also, it enables you to work through the system and make sure that you keep the dates that you set forth and different notices that you give. The eviction process, it takes a lot of time,
Right.
in general. But as long as you hire the right legal attorney and the right real estate agent on the front end, you will not get yourself into many of the problems some landlords face and even tenants on their tenancy with the landlords.
So due diligence process at the beginning is very important.
Oh, absolutely.
Right,
Yeah, you have to run your credit checks, your proper screenings. It's very important. It's one of the most important. I always recommend to my clients to use a qualified real estate agent to do this service for them. There's those free services on the internet that offer, housing for rent and this and that. But in general, I've run into more issues with my clients going off those services. And if you have a good real estate agent or even an attorney at the upfront of the screening process, it will relinquish a lot of problems you might have.
Right. That makes sense because if most people are willing to invest a little bit of fees to hire a qualified, as you mentioned, real estate agents or a specialist or specialized attorney who specializes in landlord and tenant law, that would help the matter much farther down the road.
Oh, absolutely.
Right. And in terms of finding resources, let's say if a landlord in the first place does not have an attorney who assists them or a real estate professional who can assist them to look for the right tenants. I mean, where do they look for resources and how?
In this day and age with the internet, there is a plethora of resources out there.
Google, right? Yeah.
Google,
Yeah.
We have not just Google, but you have those Craigslists. You have apartments.com.
Apartments.com.
It's a good way to at least narrow down your search for your right property down the road, but it's not the solve all. It's a good way to find the pricing and what you could afford and so on. But in general, it's about doing your due diligence and using the right professionals in the area.
Right. And in terms of finding an attorney who specializes in landlord and tenant law, where can they find an attorney like yourself who specializes in landlord and tenant law?
Yeah, there's a great resource. It's the Massachusetts Bar Association. There's AVO, which is a specialized attorney website.
How do you spell AVO?
AVVO.
AVVO, okay, .com? Or?
Yep, .com. And that, it's kind of a professional website for attorneys specifically. You also have Boston Legal Services, South Shore Legal Services, Quincy Community Action,
QCAP.
QCAP.
Right.
The newspaper.
Yeah, right. Okay. So those are resources that most consumers can look for in terms of getting help or getting knowledge about landlord and tenant laws and other rules and regs that most landlords need to know or tenants need to know, if you will. In terms of rights, I mean, what are the rights as a landlord?
I mean, the basic and fundamental rights of a landlord is, you have very broad and specific rights. You have the right to your possession of your property. You have the right to have a good tenant who pays their rent.
That's important.
And it's also, there's certain processes and procedures that also go along with that. You have a right to enter your property, to inspect, to make repairs. If you're selling your property, you have a right for lenders to come in. But the key here is, and to work with your tenants and to give them the proper notice, to allow them the time to not be there or be there. But it also relinquishes any kind of confusion. If you give the proper notice, you have a right to check, make repairs, inspect, and so on.
Right. Okay. So, what about the rights for the tenants in Massachusetts?
Yep. In Massachusetts, the most fundamental right is they have the right of habitability and the right of quiet enjoyment. And what that means is that they need a property that has, adequate heat. The bare minimum is a stove, hot water. And in different circumstances, different times of the year, it's very important that, certain regulations are followed and the landlord adheres to those.
I see. Now, for the rights and also the resources that we just talked about. Now, each state will vary, right, with their own landlord and tenant rights and law as well.
What I've found in Massachusetts, it is a very pro-tenant state.
Yeah.
And I say that, with all respect, in the fact that, tenants have a lot of right, and unfortunately landlords have to, abide by all the rules that are in place and, make sure they do everything properly.
Right. And let's show the graphics of some of the basic terms that landlord and tenant should pay attention when signing the lease or reviewing the lease, if you will.
Yep. Perfect.
So, for example, these are the terms for a rental agreement, and some of this again are basic terms. So, for example, every rental agreement must have certain terms and prohibited by law from containing certain other terms. That includes the lease must set forth the name, the address, phone number of the owner, the person responsible for maintenance, the person to whom the tenant can give copies of the formal notices, complaints, or court papers. And the following is if the landlord receives a security deposit, the lease or rental agreement must show the amount paid and must explain the tenant's right to that security deposit or money, if you will. The landlord must make sure that the tenant is given a legible copy of the lease or rental agreement.
Also, the lease must not include illegal terms such as the tenant must pay for the cost of repairing ordinary wear and tear to the apartment. The tenant must pay for repairs to parts of the building beyond the tenant's apartment. The lease must not also include terms such as the tenant may not sue the landlord for report of violations of sanitary code. The tenant may not join a tenants union. In addition, the landlord must pay late fees if the rent payment is even 1 day late. A lease or rental agreement may permit the landlord to charge a late fee if the rent payment is 30 days or more late. And again, that's stipulated in the lease and has to be clear on any type of late payments.
Right.
And spelled out very properly in that lease agreement.
Now, should the lease review by an attorney before signing for both parties?
Well, speaking to an attorney, I would say absolutely.
Hey, why not, right?
Absolutely. It's not always necessary.
Right.
If you, again, as I stated earlier,
Right.
if you have experienced real estate agent who
is competent,
is competent
right,
and does a lot of
knowledgeable.
leasing
Yes.
agreements. I mean, they know the system, they know what's required, and they also have the forms. A lot of people who try to do the lease agreements by themselves or pull off what they find on Google or
Right,
whatnot. It's unfortunate, but it's missing some, very important terms and provisions that should be in a lease.
Right, I agree. And so, as you might know, the state of Massachusetts, there are a lot of properties. I don't know what is the precise percentage, but there are a lot of properties that haven't been deletted.
Correct.
Especially any properties were built before 1978. Now, by law, does the landlord must delete if they want to rent to any families with children under 6?
Calvin, it comes to this. A landlord cannot discriminate against any person. And if the discrimination has to do with lead or the property having lead paint, I think the landlord should definitely make and do the proper steps to have it de-leaded, especially with children under the age of 6. In general, I think that any rental property should be de-leaded because you just don't know, and in certain circumstances, the lead may be tested and be not a problem, and in other aspects it could be very detrimental to any type of child or for anyone in that matter. My recommendation is to always have de-lead certificates, and if you're selling a property, to transfer those to the new owners too as proof of such.
Right, yeah, that makes sense. And so when it comes to security deposit, most landlords have asked me, should I deposit the security deposit into an escrow account or a personal account? What would you say?
Oh, that's a hot topic, Calvin. It's a topic that I often have to advise on regularly.
Right.
A security deposit cannot be held in a commingled bank account with the landlord's other finances. It has to be held in an interest-bearing account for the benefit of the tenant. It has to be separate. There has to be an accounting of such, and what's really required by law is also for the landlord to give the tenant proof of that bank account in their name or for the benefit of them, and also show them the statements, some do it monthly, some do it yearly, of the interest earned on those accounts. It, again, cannot be commingled into personal accounts.
Right.
And that is one of the biggest problems when it comes down the road if you do run into an eviction problem.
Right. So the landlord might get sued by the tenants.
Absolutely.
I see.
How Massachusetts law looks at it is if you do commingle and you do not cure meaning take it out of your account and set up a separate interest-bearing account, the tenant does have a right to triple damages.
Right.
And it could cause problems in the whole eviction process.
I see.
When it goes down to the court.
When it goes down to the court, right. So, and what is the purpose for the security deposit? Because I can summarize it, but I'd like you to summarize it if you will.
Well, again, the security deposit, it basically is for what it is. It's to protect the landlord in case of any damage done by the tenants during their occupancy. It does not cover any type of normal wear and tear. A lot of landlords basically change the carpets, repaint every time a tenant vacates a property. But it does cover damage done, and what's very important in keeping someone's security deposit, or a portion of such, is by law you must give and go through the apartment upon the execution of the tenancy and give the tenant a statement of condition. And that's a form that they sign off on, and they go walk through and make sure everything, you know, is damaged or make marks what's not, and have them sign off on that. If a landlord does not do that, a landlord cannot keep a tenant's security deposit.
I see.
So the statement of condition on the upfront, again,
I see.
using that, you know, proper form right from the beginning will cause, you know, will relinquish any type of issue in the future.
Right. Well, it's good to know. And in terms of, let's go back to the first question, eviction. Now, you said it's time consuming, a lot of work.
Yeah.
And what is the average time that an eviction would need? Like 6 months, 3 months?
Yeah,
2 months?
and that's a very good question too, and it's often asked by my clients constantly. An eviction process at the very minimal will take 2 to 3 months. It really depends on the tenancy of the tenants, and we'll get into that later on about tenancy and so on. But you know, if it's non-payment of rent, you could serve them with a 14-day notice to quit.
Yep, right.
Then if they don't come current with their rent, then you could commence the summary process and complaint then. Once that's initiated and the proper notice is served, and I say served by a constable or sheriff, is highly recommended. It gives you proof of service. It's never questioned by the court. But once that service is given and that time expires, then you go through the summary process complaint, and you fill out the complaint. And again, it's a very date specific, timing specific document that again has to be served properly and has to have the proper dates in it. And if it's not proper, you could end up redoing the entire eviction.
So in terms of notifying the tenants, where can they get the documents to do so? From the court or from the attorney or?
As far as the eviction itself, it's the landlord's responsibility. So the landlord, again, that goes into the type of tenancies.
Right.
There's a fixed term tenancy, which is, you know, for a
12
year,
months, yeah.
12 months,
Right.
2 years, 3 years.
Right.
It's a fixed term lease, and when you have a fixed term lease and it expires, you have to give them a 30-day notice to quit.
Right.
Again, that's a document served by a constable or sheriff.
From the court.
No, it gets served from the landlord or their attorney.
Okay. Yep.
And it goes through the proper channels. It goes to the constable or sheriff, then it gets served upon the tenant.
Okay.
And the same goes with, after that expires, it also goes through the summary process and complaint, same procedure. It needs to be served.
Okay.
That way, people have said that they've hand delivered it or my email serves as notice. No, it's not proper service as far as the court's concerned. You could have it served by a constable or sheriff. You could deliver it first class mail. But you always get return receipts to prove that that notice was given at the right proper time.
Right. Okay. So it's best to have certified mail or something like that. Okay.
Or by a third-party disinterested person.
Okay.
Again, that's why we use constable or sheriffs.
I see.
They put it as proof. Now, when it comes to the service of this notice to quit or the summary process complaint, it's not necessary for the person to be home or accept it. It's not being like served court papers for some other type of matter.
Right.
Proper service is being left at the property.
Yep.
Whether the person is home or not, as long as the sheriff or constable signs off on that, that it was served at a certain time and date, and that date falls within the proper range, that is good service by just leaving it at their door.
Wow. So there are a lot of steps to follow, I guess. It's
Absolutely.
not that simple.
No, it's not. And that's where a lot of people get themselves in trouble.
Right. And in terms of code-wise, what is called sanitary code in rental? What is that?
All right. Well, the sanitary code is what we a little bit discussed earlier. A tenant, especially it's a lot geared, in the more winter months. You have to provide heat to a certain temperature.
Right. Yep.
In the winter, between, I believe it's September and June. Does that sound about right?
Yeah.
You have to provide heat and hot water. And again, when it comes to heat, it's really stipulated by what the lease says. A tenant could pay for heat if it's oil heat. That's where it comes down to the upfront lease agreement. The lease agreement is very important, and that will stipulate who pays what, how it's outlined. But and then further on, basically, they have a right, the sanitary codes, not to have rodents or cockroaches or any type of varmints for that matter, and to be kept clean and orderly. It's very important, and structural issues. If there's major structural issues, a landlord is obligated to fix those and make it safe for their tenants.
Right. And in terms of, as you mentioned before, a lease agreement. Let's say if a landlord doesn't have, a new landlord especially, doesn't have or doesn't know where to find a template for the lease.
Right.
Before they consult anybody, because some people want to save some money and just do things themselves. And for those of you who out there trying to do that, I mean, what would be your advice in terms of finding a template for the lease agreement?
Yeah, like I said, again, we're lucky in this day and age to have the internet. I wish it was around when I was a little bit younger, but here we are. And with that being said, there are so many resources out there. Just simple searches under Massachusetts rental lease agreements.
Right.
As simple as that, you'll find 5-6 templates from different attorney websites to real estate rep websites to the Greater Boston forums. But what's really important for a landlord when he's looking for leases and terms and so on, there is a big difference between whether you're renting to someone in a single residential apartment or a condominium unit apartment, because there's also provisions which are governed by the condo association that require, if you do lease to a tenant, to adhere to the rules and regulations of that condo association. So it's imperative to also get those rules and regulations and attach those as an exhibit to the lease, so that they also not only conform tenants to the lease, but they also conform to the rules and regulations of the association.
I see. So great. And the advice that you have shared so far is very important, and I'm sure that your important insight will help a lot of landlord and tenants. So thank you, Bill. Thank you for being here.
My pleasure. Thank you, Calvin, for having me.
Thank you. So with all that being said, as the landlord and tenant, before entering and signing the rental agreement, be certain to review all the terms in the rental agreement to avoid any future issues between the landlord and tenant. It is important to understand the landlord and tenant right in Massachusetts, so that your rights can be protected as the landlord and tenant. Well, thank you so much for being part of the show. See you next time.